Tensions at the US-Mexican border had escalated last weekend after a group of migrants tried to get across the border near the city of Tijuana. The American Border Patrol agents used tear gas to drive them back. The border was temporarily shut down, and hundreds of people were arrested. In a press conference, President Trump later authorized the military to use, quote, lethal force against the migrants if necessary.
If they have to, they're going to use lethal force. I've given the okay. Yeah, if they have to, I hope they don't have to.
So emotions run high on both sides of the border. But let's take a few steps back and have a look at what's at stake here. The right of asylum. Who is eligible to apply for asylum? How does the application process work? And to what extent have recent political events and legal decisions altered that very process? I am going to talk about this with Stephen Yale-Loehr. He is a professor at Cornell Law School and a widely acknowledged specialist when it comes to immigration law. Steve, welcome to WVBR's Talk of the Town.
Glad to be on the show.
So let's start with a general question. What are the conditions under which those migrants would be granted asylum in the United States?
Normally, people who are overseas, who have a well-founded fear of persecution, apply for what's called refugee status. If someone's already in the United States, they apply for something called asylum. The legal test is the same. In either case, the individual has to show a well-founded fear of persecution based on one of 5 characteristics: race, religion, nationality, political opinion, or membership in a particular social group. The law says that if someone comes to the U.S. border, they can apply for asylum at the border. If they lack documents, then they first get what's known as a credible fear interview to determine whether they have at least a plausible claim to asylum. That credible fear interview has a lower standard than the actual legal burden of proof in the actual asylum hearing. Majority of people who come to the border who claim persecution do pass their credible fear interview, and then they are put into detention proceedings while they wait for their merits hearing before an immigration judge to try to prove that they qualify for asylum. That's the way it has been for years, and that's the way the statute is set up. President Trump is thinking of changing the procedures to require people to wait in Mexico to have their initial credible fear interview and their actual merits hearing. Because they've not finalized negotiations with Mexico, we don't know the details yet. And we don't know if Mexico will agree to this proposal. But if they did, it would be a dramatic change in immigration and asylum procedures for asylum seekers.
Dramatic in what way?
Dramatic in the fact that they would be in Mexico rather than waiting in the United States. And so the question is, can Mexico assure their safety? And how long will they have to wait in Mexico before they can go before an immigration judge? Will they be able to come to the immigration court proceeding in the United States, or is the United States thinking of setting up some immigration court in Mexico? All those things would have to be worked out, and there are questions as to whether, even if they did work those out, whether those procedures would comply with the U.S. obligation not to return someone to a place where they have a well-founded fear of persecution.
By making it harder for asylum seekers, is the Trump administration undermining the idea of asylum?
Well, the substantive requirements for winning asylum have not changed. People still have to show that well-founded fear of persecution based on one of 5 characteristics. The procedures for applying for asylum have changed. The presidential proclamation said that people can only apply for asylum at designated ports of entry. They are not allowed to enter outside those ports of entry. That contravenes the asylum statute, and indeed a federal court last week blocked that part of the presidential proclamation, saying that the president cannot undercut the statute unilaterally. So I would say that there are more procedural hurdles for people to be able to apply for asylum now than in the prior administration, but that the legal test for actually winning asylum remains the same.
You mentioned Judge John S. Tigar's decision to block the so-called asylum ban. The Trump administration announced that they will instigate further legal proceedings against that decision. So if it was passed onto the Supreme Court, how do you think would the court decide in this case?
That's a very good question. The administration is relying on its victory in the travel ban litigation to justify this new asylum ban. And in that travel ban litigation, the Supreme Court said that the president has wide discretion when it comes to admitting or excluding people from the United States if there are national security concerns. Here, by contrast, you have other provisions, both in the U.S. asylum statute and in international law, that say that people can apply for asylum whether they enter legally or illegally. So it'll be a clash of those two statutory provisions that the Supreme Court will have to decide which one of those gets precedence.
In a briefing on November 20th, Homeland Security Secretary Kirstjen Nielsen held specific legal loopholes accountable or responsible for the current situation.
Cartels. Our nation is experiencing an unprecedented crisis on our southern border that is the result of specific legal loopholes. They are created by poorly drafted federal law and a deeply flawed Ninth Circuit court ruling. It prevents the detention and repatriation of illegal alien minors and family units. Our weak immigration laws have encouraged caravans to try to break our nation's laws. And once again, I call on Congress to do their job and close these loopholes.
What does Nielsen refer to? And are American immigration laws really too weak, as she says?
I suspect that she was referring to a case called Florenz, which was a case brought back in the 1990s by advocates claiming that children entering the United States were not well treated. And as part of the litigation, the government settled with the plaintiffs and agreed that children coming into the United States could not be held in regular immigration custody for more than a few days. That settlement agreement is still in effect, but the Department of Homeland Security thinks that it is, in their view, a loophole that allows people to come into the United States and then get released and not show up for their immigration hearings. That's a settlement agreement that the government itself agreed to 20 years ago, and they really don't have any evidence that people do not show up at their immigration hearings. Procedurally, if people do not show up at their hearings, they are ordered deported in absentia, and then if the immigration authorities find them, they can be immediately deported.
And what about the asylum laws?
It's hard to win asylum, so I would question the argument that our asylum laws are too weak. If anything, we need to strengthen them. This so-called crisis is really one of the administration's own making. If they allowed people to apply for asylum in the normal course, we wouldn't have all these people trying to get into the United States. The president has spent more money on taking troops to the border than on hiring more immigration judges to be able to decide these cases quickly. So I think that the administration has a lot to account for politically in claiming that we have weak asylum laws.
Stephen Yale-Loehr, immigration law professor at Cornell, with some legal perspectives on the right of asylum. Thank you for your time, Steve.
Sure.
For WVBR News, I'm Florenz, Gilly.